続きまして、インゴ・ベッケドルフ欧州特許庁審判部法律審判部門部門長です。よろしくお願いいたします。
Yes, again, thank you very much. What I'm going to explain to you is rather complicated. It's rather complicated because we chose in Europe not only one layer or two layers of a judicial system. We have three layers, and three independent layers. So it gets a bit complicated, and I will try to walk you through the system that we have in Europe. The three layers in a nutshell are the following. We have the European Patent Office with its own judicial system. It's a final one in the granting procedure, but granting means pre-granting and post-granting. Then we have the national jurisdictions in each and any state in Europe, in particular the 39 contracting states of the European Patent Convention. And finally, and you heard the most predominant representative of the new court, the Unified Patent Court in Europe, Mr. Grabinski, who presented that court. That's the latest development in Europe. It represents 18 countries. So if you compare 39 with the European Patent Office organization on the one hand and 18, but the Unified Patent Court is not yet at its end, it may at one day in the future may cover the entire European Union member states, which are less than the 39 that we have at the EPO. So that I think gives you a bit of a picture, and I try to give a bit more flesh to this complicated skeleton that I described. The European Patent Organization has two main parts. That's the European Patent Office as the patent granting office authority, and the Administrative Council as the legislator and supervising body. And in between, we have since 2016, although still a part of the European Patent Office, but it's a separate part of the European Patent Office, are the Boards of Appeal. And the Boards of Appeal have a counterpart at the Administrative Council with a Board of Appeal committee. That's not a supervisory committee, it's an advisory committee, but we have now our own, if I may say so, representative at the Administrative Council as the legislator. And in these meetings of the Board of Appeal Committee, usually it is the president of the Board of Appeal, and I'm with him as his deputy to inform the Board of Appeal Committee and to get their advice or recommendations as well. The Boards of Appeal, I already mentioned this, and I refer to what I said before. The Boards of Appeal are the first and final judicial body in the system under the EPC, under the European Patent Convention, the first and final judicial instance to review the administrative decisions of, in particular, the examining divisions for the granting of the patent and the opposition division dealing with oppositions to granted patents. We do have a bit more complicated system. I'll come to that in a minute. So I already mentioned, if you see the overview, we have two stages of the proceedings, granting proceedings in the European Patent Organization. That's the administrative part with in particular the examining divisions that I just described and the opposition divisions, but there are also legal divisions and receiving sections. I will skip that. The appeals to those decisions will then go to the Board of Appeal, in particular to the technical Board of Appeal, of which we have 25, all composed, all deciding in a composition of 3 or 5 members. It's a combination of technically qualified members and legally qualified members or judges. What they issue is a final decision, with one exception, that this decision can be petitioned to the enlarged Board of Appeal, but only for procedural reasons, not on the merits, not on the technicality or on technical issues. And there we have rather few ones that are filed. In case that a petition for review is allowed, then the proceedings before the Board of Appeal are reopened again for a second round, for a second hearing. And we also have the possibility, I explained this earlier, that a Board of Appeal or the President of the European Patent Office can make a referral of questions of law to the enlarged board, in particular on the interpretation of the EPC and the harmonization of the case law of the Boards of Appeal. So that was already covered. Now the structure of the Boards of Appeal. As I said, we have a president. The president is advised by a presidium of elected members and chairpersons. Then we have the 25 technical boards of appeal. They are distributed along the technical fields, mechanics, chemistry, and physics, electricity. We have the legal board of appeal and the enlarged board of appeal. The president of the board of appeal is also the chair of the enlarged board of appeal. And just to explain to you where I am situated in this diagram, I'm situated in the legal board as the chair of the legal board, but I'm also the deputy chair of the enlarged board and deputy chair of the disciplinary board of appeal. Sorry for this complicated situation, but we deal with many different issues. And we are assisted by administrative services of the boards of appeal. That is the legal services, which is composed of the legal research service, which issues the famous case law book that I mentioned earlier in my first presentation, and the legal advice service that is there to give advice to the president of the boards of appeal, and here I'm also the head of the legal services. So I have different functions, several functions in the boards of appeal. And then we have the general administrative services of the boards of appeal, covering HR issues, for example, but in particular covering the registry, that is the registry of the boards of appeal. Each board has one dedicated registrar to assist the formality work in the board. So now we come to the to look at the situation of the Board of Appeal vis-à-vis in the national courts and the UPC. As you see, there are two different lines. There's the line for the EPO Boards of Appeal, and this ends, or this concerns the patent granting procedure, and this ends, and there's no direct line between those proceedings before the Boards of Appeal, EPO and Boards of Appeal, and the proceedings before the national courts and the UPC. Why? Because the national courts and also the UPC, they deal in particular with patent infringement cases. They also deal with validity cases. As we do, we call those cases not validity cases, we call those cases revocation cases. And there we do have a kind of overlap. Because for those patents that are valid in the jurisdiction of the national court in 38 contracting states of the European Patent Convention, or that are valid as so-called unitary patent, something that Klaus Grabinski mentioned yesterday as well. The unitary patent, which are applicable in 18 EPC contracting states and EU member states, here we have to pay attention. Because as we do not have any direct relationship between the two court lines, they have they influence. There's an interrelationship. There's an influence between the two, for one simple reason. If there are parallel proceedings, for example, there's a validation proceedings before the UPC or before a national court, and at the same time, no, it can only be before the UPC. Before the UPC, and still an opposition appeal proceedings before the Boards of Appeal. Depending on the outcome in our proceedings, this may change the entire setting for the UPC as well. One example. We revoke, at the Boards of Appeal, revoke a patent. Then this patent is revoked in all countries and all states for which protection was sought. Also in those states that are contracting states of the Unified Patent Court. So that would end the proceedings before the UPC immediately. The other way around, the UPC revokes a patent in validation proceedings, then this has an effect on our proceedings as far as we have protection for the same countries, i.e. 18 contracting member states. For the rest, for the 11 other states, we have to continue our proceedings because that was not covered by the judgment of the UPC, even the final judgment of the UPC. This means that we have to follow, and that's our responsibility, what I call the shared responsibility. Here you see the different areas. The blue ones are the UPC countries, and the red ones are the additional countries covered by the EPC. The blue ones are also EPC countries. So what does this mean? This means that we have a shared responsibility, and that we need to inform ourselves about the parallel proceedings. We have access, or we are informed by the UPC on any proceedings that are initiated before the UPC. And our proceedings are anyway transparent because we have a public file. And so the UPC always knows if there are still pending proceedings before either the opposition proceedings on the one hand or the Board of Appeal on the other hand. And we have also established a system where a UPC judge, for example, can get in touch with a Board of Appeal, with a competent Board of Appeal, to discuss the case not on the merits, but to discuss, for example, when the next oral proceedings is planned, when a decision is likely to be issued, and this is something that is still in the building. But I can assure you that we have a regular contact, not only at conferences, but we have also established a direct contact with the UPC, and I will meet Klaus Grabinski in 2 weeks' time to discuss institutional matters in order to facilitate, to enable, in the interest of the users, in the best interests of the users, that there are no contradicting decisions coming from those two courts. We cannot influence, for the judicial independence, influence the outcome of proceedings, but what we can do is to inform ourselves about the proceedings and to try to discuss approaches. And this is something, as we will do very shortly with the panel discussion. This is something that in a different concept, but with the same idea behind, is also to be established between the different layers that we have in Europe with the national courts, the UPC, and the Boards of Appeal. One example there: we meet with national and UPC judges every year for a so-called expert workshop on the premises of the EPO to discuss the most relevant topics, or the hot topics that we consider to be worth of discussing. Last point on this. This is a bit of our harmonization philosophy that we have established. There's one point that I would like to take a look in the next minute, is the stay of proceedings. Here, what we have established as a concept is the concept of acceleration. I shared with you our pendency time that is a lot higher than the ones in the US or in Japan. This means that we have established, both in the office for the administrative proceedings, but also, and in particular at the Boards of Appeal, a system of acceleration. And the acceleration of the proceedings works as follows. If a party or a court request acceleration, then this request is by default being granted. Or if we learn about parallel proceedings, be it infringement or validation proceedings, then we accelerate ex officio. And acceleration means that we are, depending on the stage of the proceedings, we are able to deliver a decision within maximum of 12 months. Whether this, so far we haven't yet received any request for acceleration from the UPC, but this may change in the future with the increasing workload there. But this is something that we offer in addition to the system of transparency with the communication, with the preliminary opinion that I explained to you as the first materializing view of the judiciary of the EPO on a certain case. So those are the articles, the provisions in the rules of procedure. It's Article 10, and there you see in Article 10.6 Article 10.5 the ex officio acceleration, and this means then that there will be a strict procedural framework also for the parties, reducing time limits to the minimum and asking parties to concentrate on the case. And the UPC may also stay proceedings awaiting a decision of the Board of Appeal. Thank you very much.
ベッケドルフ部門長、ありがとうございました。